By briefly explaining why this bill has been developed, and then I'll ask my colleague Marguerite Clark to then go through the bill in a little bit more detail. The Minister for Agriculture, Fisheries and Forestry and the Minister of Environment and Heritage and Minister for Aboriginal and Torres Strait Islander and Multicultural Affairs are collaborating on implementation of the government's policies on dugong and turtles. So I welcome the representatives from the Department of Aboriginal and Torres Strait Islander and Multicultural Affairs that are here with us today, Carmel and Peter. Before the election, the current government announced a policy protecting Queensland's precious wildlife, dugong and turtles, that committed them to amend the Animal Care and Protection Act to bring Queensland in line with other states, removing exemptions for traditional owners. They're the words out of the election policy. The policy was explicit that the government would remove the current exemption for traditional hunters from the law that makes it illegal for anyone to wound, mutilate, torture or unnecessarily prolong the death of an animal, enforceable with penalties up to 2 years in jail or a $100,000 fine. In its first 100-day action plan, the government committed to implementing this policy during its first 100 days of government. The Minister for Agriculture, Fisheries and Forestry introduced the Animal Care and Protection and Other Legislation Amendment Bill 2012 on June 19 to meet that commitment. The bill will repeal Section 8 of the Animal Care and Protection Act 2001, which currently exempts Aboriginal or Torres Strait Islander people who deal with animals in accordance with Aboriginal tradition or Islander custom from the animal welfare obligations under the Animal Care and Protection Act. This will mean that animal welfare obligations apply to acts done or omissions made by any Aboriginal person under Aboriginal tradition or an Islander under Island custom. The repeal of Section 8 will bring Queensland's animal welfare legislation in line with other states. All other states prohibit animal cruelty, although the way the legislation is worded in each state is slightly different. No other state exempts Indigenous people from the prohibition on animal cruelty. The bill will also amend some other Queensland laws that currently allow Aboriginal or Torres Strait Islander persons to undertake traditional or customary hunting of turtles or dugongs without being subject to the animal welfare obligations under the Animal Care and Protection Act. The bill will make hunting under these acts subject to the Animal Care and Protection Act 2001. I need to make the point that the bill will not extinguish native title rights to hunt, nor will it rescind any other hunting rights. The bill will, however, regulate how hunting rights are exercised. Animals will need to be killed in a way that causes as little pain as possible. At this point, I'll hand over to Marguerite to go through the bill or the changes in more detail.
So my name is Marguerite Clark. I'm from the Department of Agriculture, Fisheries and Forestry. Those in the chamber will have a copy of the bill in front of them, but if you read the bill from beginning to end, it's quite confusing because the amendments are in alphabetical order by the name of the Act that they're amending. So what I propose to do is actually to begin in the middle of the bill and start with the repeal of Section 8 of the Animal Care and Protection Act. If you want to follow this in your bill, that's Clause 8 of the bill. So Section 8 of the Animal Care and Protection Act currently excludes acts done or omissions made by Aboriginal and Torres Strait Island people in accordance with Aboriginal tradition or island custom from the application of the Animal Care and Protection Act. The bill would repeal this section. Repealing this section will mean that the animal welfare requirements under the Animal Care and Protection Act will now apply to Aboriginal and Torres Strait Islander people. These welfare requirements include a prohibition on animal cruelty. Now, native title is protected under the Commonwealth Native Title Act. It limits when and how legislation can validly affect native title acts. But the government's view is that imposing animal welfare obligations on the way native title acts deal with animals is valid under subdivisions M and N of the Commonwealth Native Title Act. In other words, we think that repealing Section 8 and other aspects of the bill is valid under the Commonwealth Native Title Law. To make it clear that native title holders are intended to be subject to the Animal Care and Protection Act, the bill actually replaces the existing Section 8 of the Animal Care and Protection Act with a new section which clarifies that native title won't be a defence to animal cruelty. The Animal Care and Protection Act doesn't provide an exhaustive list of what's cruel, but it does include some standards to guide the courts when deciding whether something is cruel. The first standard, perhaps it's the most fundamental, is that something's cruel if it causes an animal pain that, in the circumstances, is unjustifiable, unnecessary or unreasonable. There are also some other standards to guide the courts in more specific circumstances. I won't go through them all, but the important one is that when it comes to what's cruel when killing an animal, the Act says that it's cruel to kill an animal in a way that's inhumane, causes it not to die quickly, or causes it to die in unreasonable pain. These are the tests that apply for cruelty for all Queenslanders. However, the currently available methods of killing turtles and dugongs that are humane and cause quick death may not be practicable in the circumstances in which hunting sometimes occurs. So to balance the welfare needs of turtles and dugongs and the hunting rights and interests of Aboriginal and Torres Strait Islander people, the bill introduces a new section into the Animal Care and Protection Act, Section 41, and if you're following the bill, that's in Clause 10. So it introduces a new Section 41A that will effectively give hunters a defence to prosecution for killing turtles and dugongs using more practical methods if they can show that those methods cause as little pain as is reasonable. I want to draw your attention to the similarity between the way the bill proposes to deal with the competing interests in traditional and customary hunting and the way the Act already deals with competing interests in the control of feral and pest animals. Those people dealing with a problem with feral and pest animals may find it difficult to control them in a way that's humane and quick. Under the Animal Care and Protection Act, there's a defence to prosecution for those controlling pests and feral animals if they can prove they controlled them in a way that caused as little pain as is reasonable. That's the same test that's proposed to apply to those undertaking traditional customary hunting. Those are the main features of the bill. The rest of the bill can be summarised as proposing to remove other exemptions in Queensland legislation that could prevent the animal welfare obligations under the Animal Care and Protection Act from applying to hunting. The bill will first of all amend Section 7 of the Animal Care and Protection Act to ensure that a person who's authorised to deal with animals under the Nature Conservation Act, in accordance with Aboriginal traditional island custom, is subject to the animal welfare obligations under the Animal Care and Protection Act. The bill will also amend the Aboriginal and Torres Strait Islander Communities, Justice, Land and Other Matters Act. They're the first three clauses of the bill, to ensure that a person who's authorised to hunt marine fauna under Section 61 of that Act is subject to the animal welfare obligations under the Animal Care and Protection Act. Very similarly, the bill will also amend the Arakoon and Mornington Shire Leases Act 1978. Again, it's to ensure that an Aboriginal person who's authorised to capture, possess, kill or consume native fauna under Section 26 of that Act is subject to the animal welfare obligations under the Animal Care and Protection Act. It will amend the Nature Conservation Act to ensure that someone who's authorised to deal with animals under Section 93 of that Act, if it were to commence, currently it hasn't commenced, would be subject to the animal welfare obligations under the Animal Care and Protection Act. In other words, the amendments to all the other acts are simply to ensure that people who are authorised to undertake traditional or customary hunting of turtles and dugongs will be subject to the Animal Care and Protection Act.
We are well on the way to gorgeousness.
It's Jim Thompson again, just to add to that, I guess Marguerite's gone through the main issues that are there and the main changes that are being proposed. I'd just like to talk a little bit about communication implementation strategy, because I know these issues will be raised. The communication implementation strategy will be led by government. To be led by government is being finalised and will be implemented during the 6-month period that will apply after the Act is passed by the Queensland Parliament. In the initial information phase of the strategy, the state government will communicate the intention of the proposed legislative amendments broadly to all key stakeholders. The Minister for Aboriginal and Torres Strait Islander and Multicultural Affairs will lead the communication strategy and will write to Indigenous councils, peak bodies, community organisations, land and sea management agencies and land holding bodies in coastal areas and all relevant identified parties in order to broadly communicate the intent of the amendments. Furthermore, we intend to discuss the amendments with relevant community leaders in the forthcoming visits to the communities of Weipa, Napranum, Hopevale and Palm Island, and subsequently in the conduct of ministerial responsibilities. Phase 2 of the strategy will highlight communities and community leaders who practice humane hunting methods or are actively working to develop humane hunting methods, and also actively engage with communities where there is evidence of community concerns in relation to the effect of these amendments. Communication and consultation will acknowledge the long-term work of many communities in dugong and turtle sustainability, and in particular sustainable hunting practices, and will encourage community-led efforts to ensure hunting practices cause as little pain as is reasonable. The government is committed to working with the communities regarding the proposed legislation and will utilise opportunities arising from the existing range of cooperative management arrangements